All attendees are in listen-only mode.
Good afternoon. This is Chris Fryan of Percentra Group. Thanks for joining us today for our webinar on NLRA and for at-will employers. Chris Brown of Percentral HR is going to be leading us through today's topic. Just a couple of items before we get started. If you do have any questions throughout the presentation, we ask that you enter them in the dialog box, and we'll have Chris address those at the end of the session. Also, today's session is being recorded, and we will have the slides along with the recording available shortly after the presentation. Finally, we anticipate that the webinar will be approved for HRCI credit through the HR Certification Institute. And once we receive that program ID, we'll be sending that to all the attendees of this live session. So at this point, I'd like to turn it over to Chris Brown to get us started for today. Chris?
Hi, thank you. And so we've got sort of a what you might call a hot button topic today. It's something that has become a bigger concern for a lot of employers over the last several years, and that is the National Labor Relations Act. And I think the reason that it's something we get so many questions on today is that for many years, at-will employers and the vast majority of firms in the United States fall into that status. For a very long time, at-will employers were completely oblivious to the National Labor Relations Act. They just didn't even think about it. If they had heard about it, they thought that it didn't even apply to them because they didn't have a union. You know, if I don't have a union, why do I care about the big union law? But the National Labor Relations Act has always applied to all employers. The issue was that for many employers, they just didn't really have to worry a lot about it because they had non-unionized workforces and their workforce was in no rush to unionize. And I still think that most workforces are in no rush or even have an interest in unionizing. But there's been some changes at the National Labor Relations Board over the past several years that have put it on a much more aggressive footing in protecting the rights of at-will employees. And so that's what we're going to be talking about today. So just in the way of background, the National Labor Relations Act was enacted in 1935, and the entire purpose of the law was to encourage collective bargaining, and it encouraged collective bargaining by creating a lot of protections for employees who engaged in activity to collectively bargain and form a union. It also put a lot of restrictions on what employers could do in that kind of situation. And so we'll give you a little background on kind of why this law passed in just a moment. Here are some, we pulled these right off of the NLRB's website, so these are from them. But here you can see a New York Times article from the time. You know, this was a law that was really pushed by FDR, and then I also thought this was really interesting. This was from a labor group that was promoting themselves, and I don't know if this is, and this is a quote from FDR: "If I went to work in a factory, the first thing I'd do would be to join a union." And so there was very much a pro-union sentiment in this time period with the administration, and they were able to get this law passed, and it was very much a law designed to assist in the formation of unions. There's no ambiguity about it. I mean, that was the purpose of the law. Now, a lot of employers today don't give it any thought because they're at-will employers, like I was mentioning earlier. And, you know, as a reminder, you know, employment at will is a legal concept that applies to employees who can be terminated without cause. And I always like to point out that it's just a legal concept. It's just sort of an idea because there are so many ways that an employer can still get in trouble even with at-will employees. I run across employers all the time who do really, really stupid things, and their argument, well, it was an at-will employee, so I could just fire them anyway. Not in real life, okay? So even though most employees in the United States are employed at will, there are many exceptions to the at-will status. There are public policy exceptions. So if terminated employees would be contrary to public policy, it can be an exception to create an exception to their at-will status. There can be implied contract exceptions. In a lot of states, this is a major concern where we have, a situation where there's some implied contract, and that erodes the at-will status. We have a whole range of anti-discrimination laws that an employee could bring suit under if they were terminated and there wasn't a legitimate cause. So even if an employee is employed at will, and there's no debate about the fact that they were an at-will employee, if they don't like the reason they were terminated, they could argue that the termination somehow violated some relevant anti-discrimination law, whether they claim that they were discriminated against based on age, gender, national origin, sexual orientation, whatever the case might be. That could pull an employer into court, and they could, have a very unpleasant outcome because of that. Whistleblower protections can protect employees who are otherwise at-will employees. Anti-retaliation laws can protect employees who are otherwise at-will employees. So just because you have at-will employees doesn't really mean you can just terminate them anytime you want to. My advice to employers has always been, call them at will, state in the handbook that they're at will, refer to them as at will, but anytime you're terminating somebody, make sure you're terminating them for a cause and that it's well documented, and so it doesn't appear to be discriminatory or arbitrary. And I think that that is a really good way for employers to protect their interests because of the fact that there are so many situations where even if an employee is unambiguously an at-will employee, we still have a whole range of protections for those individuals that could, land the employer in court. So what was the rationale behind the National Labor Relations Act? So prior to its passage, employers did all kinds of nasty things to prevent unionization. And I mean, even if you really oppose unions, all right, and I'm kind of in that camp myself. I have not had a lot of positive experiences working with unions in different industries. I mean, some have not been so bad, but I've had some unpleasant situations working with unions. So even if you're totally opposed to unions, if you look at what was happening in the 1930s when employees would try and form unions, you can understand when the NLRA was passed. I mean, some employers, and we've got some great examples in here, were using really brutal tactics to try and protect against the formation of unions by their employees. So the NLRA, when it was passed, provided federal protection to the employees seeking to organize. And so one of the famous cases, and this was well before the 1930s, but this is kind of one of the classic examples of what some of the ugly stuff that was happening at the time, was the strike at Homestead Mill. And this was the late 19th century, just before the turn of the century. We had it's the city of Homestead. The employer at the Homestead Mill had brought in Pinkerton Detective Agency, which was widely used during this era to try and prevent unionization or to bust up unions. And these Pinkertons, many of whom were migrant workers, were brought in by the mill owners to disrupt the threat of a strike. And so we basically had the employees fighting against these private detectives who had been, and you got to understand that the Pinkerton agency at the time had so many employees that they were actually had been outlawed in some states because of the concern that they were effectively a private militia. And so these weren't, this wasn't like Dick Tracy walking around looking for clues. These were thugs for the most part. They were hired by employers and to prevent unionization. The mill workers fought. They ended up capturing 300 agents from Pinkerton, eventually ran them out of town. But the mill workers eventually returned to the mill without a union because they couldn't afford to stay on strike. and I'm sure that if it hadn't been for the involvement of these thugs from Pinkerton, the situation might have been a little bit different. There was a similar situation closer to when the NLRA was passed, and this was at Ford Motor Company. And a lot more people have heard about this than the Homestead Mill case. In the late 1930s, organizers came to unionize Ford Motor. Henry Ford didn't want a unionized workforce, and his quote was he didn't want his company to be run by a union. So who did he hire? He hired Pinkerton to come out and help, bust up the union. And they were known for their extreme use of force to prevent unionization. And so you had all these employees who had broken bones, serious injuries, there were alleged deaths. And so this was the climate that the National Labor Relations Act came about in. And so, if you really hate this law, as many employers do, and you really hate the idea of unions, just keep in mind how bad some employers were during this period in attempting to prevent unionization. I mean, hiring basically a private army to come in and beat up your employees. There are tons of other examples, this Pinkerton Detective Agency, where they would infiltrate unions and effectively shut down the union by running off all the other members of the union, getting themselves elected to run the union, and effectively, dismember the union. So I mean, there were a lot of tactics that even the most anti-union employer today would probably cringe at that were going on during this time period. So part of with the passage of the National Labor Relations Act was the creation of the National Labor Relations Board. So we have a law, we have to have somebody who's in charge of the law. And so this was similar to the case with other laws that have come after. So for example, Title VII created the EEOC. The Occupational Safety and Health Act created OSHA, Department of Labor agency that enforces the OSH Act. So it's not uncommon that when we create a new legal protection that we also get a new, governmental agency. In this case, it's the National Labor Relations Board. And they're an independent federal agency, and they've got broad power to safeguard employees' rights to organize and determine whether to have unions as their bargaining representative. So that's why a lot of at-will employers are like, hey, NLRB, I don't have to worry about NLRB because I don't have a union. The problem is that it's not just employees that have unions that are protected by the National Labor Relations Act. It's also employees who might theoretically want to create a union or form a union who are protected by the Act. And that includes this preventing and remedying unfair labor practices committed by private sector employers and unions. They hardly ever go after a union. It's almost always an employer. The board has 5 members, and they act as a quasi-judicial body in deciding cases on the basis of formal records and administrative proceedings. They also have administrative judges, and they also have a chief counsel who is responsible for effectively, prosecuting cases in front of them. They're appointed by the president to 5-year terms with Senate consent, and one person expires each year so that you have staggered terms like other federal agencies. What you'll see, though, is that because of the way the NLRB is staffed, it can become somewhat dysfunctional. And so what had happened is that effectively for the last several years of the previous administration, no new members were added to the NLRB. So people's terms would expire and they would not be replaced. And the reason for that was, of course, because there was some substantial disagreements between the executive branch and the Senate in regards to who was a suitable candidate for the NLRB. And you can imagine that, Democrats in the Senate had one view of who was a good candidate for the NLRB, and the Bush administration had a different view of who was a good candidate for the NLRB. And whether it's right or wrong, the fact is they couldn't agree. And so we got to the point where there were only 2 members left on the NLRB for a 27-month period. And so basically you had 2 people if those two people couldn't agree on something, it didn't get done. Now, interestingly enough, later, after new members were added, there were some challenges made against rulings that occurred during this time period because the NLRB did not meet its quorum requirement, which is imposed by Congress, that there be at least 3 members for any decision. So they actually were below the quorum. Now, they kept issuing decisions during this period, albeit not that many, because these two people who were left on the board disagreed on a lot of things. So it was really only in circumstances where there were major and obvious violations of the National Labor Relations Act where they really issued any rulings at all. And so it was very dysfunctional because of that. Later on, many of their rulings were subsequently invalidated because they didn't meet the quorum requirement, which is a whole separate issue. But anyway, we had a 27-month period where there were only 2 members. In 2010, as we set up here, when the executive branch and Senate were more aligned ideologically, we started getting new members. Unsurprisingly, many of the new members have ties to organized labor. So some of them used to be attorneys for organized labor. Some of them used to just have other positions where they acted on behalf of organized labor. So effectively now the NLRB is primarily composed of board members who have some sort of connection to or are very sympathetic to organized labor. So because of that, you now have a much more activist NLRB, and that's what's got a lot of employers worked up now, because you went from a basically dysfunctional NLRB that couldn't do anything because there were only 2 people, and if they couldn't agree, nothing happened, to now you've got a fully staffed NLRB, and it's staffed with people who are very sympathetic to labor. So not surprisingly, their decisions are primarily very sympathetic to labor. And once again, right or wrong, this is just reality. I'm not going to get into the politics of it. The facts are just the facts. You've got an NLRB now that has a lot of decisions and is making a lot of changes, and a lot of those changes are either implicitly or explicitly designed to benefit unions. So they've moved much more aggressively over the past couple of years to enforce the act with at-will employers. And this makes sense because, and I probably should have included a graph on this, but I didn't, union membership over the past decades has been going down dramatically. I think the latest number, and somebody might say that I'm wrong about this, I think it's something like 11% now of private sector employees are unionized. That might even be wrong. It's a very small number. It's gone down dramatically. So basically we have a situation where the unions have been losing members, and because of that, in the United States, there has been a substantial decline in the number of employees who are represented by a union. That's bad for business for unions, and so the NLRB has been moving much more aggressively to provide whatever assistance they can in increasing that number, you might say. So the first big thing that kind of happened when the NLRB got its new members, and they were on a roll to help increase union representation, we have this poster that comes out. And this was brand new, and this was not an explicit requirement of the National Labor Relations Act. But if you look at many old labor laws like the NLRA, it's not really that unusual that that we have a no explicit posting requirement. So the NLRB, and their authority with their new members, decides we want every employer in the United States to hang up this poster, and this is what the poster looked like. Hey, you may even have it hanging up. This was good business for poster companies, who are always excited when a new poster comes out, because they can take this poster that they get for free from the government, stick it on a gigantic piece of paper with all their other free government posters, and sell it to you for a fee. And so they were happy to send out all sorts of notices to employers that you need to buy a new poster and hang this up right away so that you include this right. Well, not surprisingly, a lot of business groups were very opposed to this poster. Honestly, I don't really see why they cared all that much. I don't know that there are that many employees who are going to look at this poster and say, oh my gosh, I didn't know that under federal law we have the right to form a union, and now that I've seen this poster, let's run out and form one. Most employers are at a very, very low risk of having their employees organize a union for a whole variety of reasons. But this, to me, I just never saw that this poster was going to cause, massive unionization. But the NLRB wanted it. Business opposed it. They ended up in court. A three-judge panel for the U.S. Court of Appeals for the D.C. Circuit struck down the rule in May 2013. And so because of that, there were several delays while this was in court. Originally, there was a filing. There was a deadline by which all employers were supposed to hang this thing up. That deadline passed, and we were back and forth in court. Then another panel of the U.S. Court of Appeals ruled that it concurred, and then finally the NLRB late last year decided that they weren't going to appeal to the Supreme Court, and so effectively the poster requirement was dropped. However, and here's the thing, so this is now a voluntary poster. As an employer, you cannot be compelled by the NLRB to hang this up, so you do not have to put it up. However, the NLRB has said on a couple of occasions that while you do not have to put it up, if we are investigating you for unfair labor practices, one of the things that we will consider is whether or not you hung up our poster. Now, I know this kind of sounds like blackmail, and maybe you could argue that it is, but they can't force you to hang up the poster. However, they have some discretionary authority in the event that they're investigating your business for unfair labor practices, and they've kind of gone on record saying that, hey, when we're looking at your business and deciding whether or not you've engaged in unfair labor practices, we might take a look to see if you're hanging up our voluntary poster. And if you're hanging up our voluntary poster, then, you get sort of an invisible check mark, and we like that. So if I were an employer that was not overly concerned about unionization, I would probably just hang it up. It's probably not going to have any major effect on whether or not my employees unionize, and if for some reason I were investigated by the NLRB, I can say, hey, look, I put up your voluntary poster. I let my employees know about their rights under the Act, and then hopefully you haven't done anything bad, and you're not hit with any fines or penalties. So one of the things that people often ask when we're talking about any of these compliance issues is, well, what could go wrong? What could happen to me? So I just pulled some recent court cases, not court cases, NLRB decisions and agreements to give you some ideas of this. So this was a $900,000 settlement for 2 Texas workers. Catch that, 2. This wasn't a $900,000 settlement for some huge class of employees. This was for 2 people who got fired. So interesting thing about the NLRA is you can actually have much larger penalties that you can under some other laws. I mean, it would take something to get up to $900,000 for 2 employees for FLSA violations, unless there was some, even then it's hard to imagine how this would happen. But under the NLRA, it's possible. So, and what's interesting is this was a small employer. It was the Texas Dental Association. So how many employees does the Texas Dental Association really have? It represents a lot of members. I think it says there were 7,000 dentists or something who were members, but this is an association that's got a handful of employees. This is not a huge company. So they had to pay $900,000 in back pay to 2 former employees who were fired in relation to a petition complaining of poor management. And so basically these employees had gotten together and they put together a petition that they then sent out to the members of the association, so those, the 7,000 dentists, saying, hey, we think there's mismanagement here and we want to be treated better. Well, what happened, though, is this petition was signed, and the employer did not like it, And so the association declined to authorize an investigation, and the association director wanted to find out who these, who the 11 employees were. So they did a forensic analysis of the office computers. They found one employee who helped write the petition. That employee was fired for writing the petition, and then another employee, the supervisor, who refused to give out the names, was also fired. So 2 people were fired, 900 grand. And I doubt these were employees who were making hundreds of thousands of dollars a year. So this is a pretty substantial settlement when you're considered it's just for 2 employees. So that's how bad it can get. Here's a plastic surgery center, also in Texas. This is just a coincidence. It was a plastic surgery center in Dallas agreed to pay more than $300,000 that had unlawfully fired 2 employees. Then they turned around and sued one of them, which is just kind of crazy. And this is the name of the company. I mean, it's all public record. And what was it over? Wage discussions. One of the most common complaints we see with at-will employers in the National Labor Relations Act is where an employer has a policy prohibiting employees from discussing their wages. Common policy, see it all the time. Look at handbooks all the time. When we do handbook reviews, probably 1 in every 3 or 4 handbooks we look at has got something in there about not discussing wages. And that has been considered a violation of the National Labor Relations Act for ages. It's something that employers still do. And here's what happens. You fire the employees because of it. I mean, now going and suing them, this was just stupid and a waste of money. The employer suing the employee, but anyway, this medical practice had to pay $300,000 for 2 employees that they fired. And once again, these were probably not high-wage employees. So we really have to look at what kind of practices, your average employer might have. And the wage discussion thing is just such a common example of that, but we've got some other things that you're probably less familiar with. What are the kind of things that could get an at-will employer in hot water with the National Labor Relations Board? And there's a lot of them. So first, let's talk about Section 7. So Section 7 of the NLRA guarantees employees the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other activities. These are called protected activities you'll see elsewhere for mutual aid or protection, as well as the right to refrain from any activities. So they can't. So if a union was coercing an employee into joining the union, the employee could complain to the NLRB and, in theory, be protected. And then Section 8 makes it an unfair labor practice for an employer to interfere with, restrain, or coerce employees in the exercise of their Section 7 rights. And so you'll hear about all of these things being Section 7 violations. And these are basically any time an employer has violated the right of those employees to do any of this stuff up here. So we got some examples, and these are examples from the NLRB. So they're sort of official examples, you might say, of things that an employer cannot do. And I'll kind of elaborate on some of them to give you ideas of how, even though you might not think you're explicitly doing some of these things, you might be doing them by accident, or you might be unaware that your supervisor doing these things. So you can't threaten employees with adverse consequences such as closing the workplace, loss of benefits, or more onerous working conditions if they support a union, engage in union activity, or select a union to represent them. So if your employees, for whatever reason, are complaining about their wages and they say, hey, we should get together and try and get our wages increased, and you go out and say, look, guys, if I'm forced to increase your wages, I'm just going to have to shut this place down. What did you just do? You just violated Section 7. Can't threaten employees with adverse consequences if they engage in protected concerted activity. So if they work together, okay, to try to better their lot collectively as employees. So this could be if you just have 2 employees talking about their wages, saying, hey, we're not getting paid enough, we should get a raise, and you say, hey, you guys aren't allowed to talk about this stuff. you have just violated Section 7 because you prevented them from engaging in protected concerted activity. And so that is concerted, and you can read the definition here, but this is why we can't prevent employees from communicating with each other about wages or working conditions. We can't promise employees things if they reject a union. So this doesn't come up that often because most employees aren't really planning to form a union. But if you have employees who come to you and say, hey, we were talking to the whatever group that came in, and we think that it might be good to form a union, or whatever the case, or you just hear about it and you go to all the employees and say, hey, if you guys reject the union, we're going to give everybody a raise, yay, because we want to give you a raise. That's against the law. That's a violation of Section 7. We can't imply any promise of benefits by soliciting grievances from employees during a union organizing campaign. So we can't ask employees to, find out what their problems are so that we can try and address those, to prevent the unionization. We can't confer any benefits on employees during union organizing campaign to induce employees to vote against the union. So if all of a sudden you're like, hey, everybody gets a free day off and a raise and this, that, and the other, you didn't threaten, you just gave it to them. That is a violation. We can't withhold changes in wages or benefits during an organizing campaign that would have otherwise been made. So if people were due for, maybe there's an annual cost of living adjustment that your company gives, and you decide not to do that while they're in the state of attempting to organize or consider a union, that's a violation. You can't coercively question employees about their own or coworkers' union activities or sympathies. I just always assume that any questioning is coercive, so I would just not ask them about it. Once again, it's only illegal if it's coercive questioning. So in theory, you could non-coercively question your employees. But once again, whether or not something is coercive is going to be decided by people who aren't necessarily looking out for your interests as an employer. So I would just not question employees about that. We cannot prohibit employees from talking about a union during working time if we permit them to talk about other non-work related subjects. So if you have a no talking at work rule, then you could impose your no talking at work rule, and that could include any talk about the union. But if you allow employees to talk about other things, you have to allow them to talk about the union. You can't poll your employees to figure out, whether or not you're going to, whether or not a unionization attempt is going to be effective. So that's a violation. We can't spy. So not only can we not spy, but we can't create the impression that we are spying. So doing anything that you wouldn't ordinarily do is potentially spying. So if you already have up cameras and the cameras happen to capture people talking about a union, that wasn't spying because you already had up cameras. But if you go and put the cameras up when employees are considering unionization, then that's going to look more like spying. If you have any employees followed, photographed, videotaped, anything like that, that's going to be a problem. And they actually specifically address that here. We can't do anything to employees who are engaged in peaceful union or other protected activities. Now, if we have employees, lobbing Molotov cocktails over the fence at our factory, then that's a different situation. But if they're just standing outside talking about the union, picketing, doing anything that's peaceful and legal, then we can't photograph or videotape. Now, interestingly enough, this in no way prevents them from doing that to you. So, for example, unions, and we don't want to just pick on employers here, some unions and some employees also employ some fairly despicable tactics. And so there are unions who will take photos of executives of companies and get billboards, saying, shame on you, Mr. Executive, for what you've done. I've seen situations where unions put giant inflatable rats in front of executives' homes. So the ability of the employees and the unions to do things is somewhat different than what the ability of the employer to do things. So there are things that they can do that you can't do. We can't solicit individual employees to appear in a campaign video, so we couldn't, for example, ask employees to make a video of why they oppose unionization. We can't promulgate, maintain, or enforce work rules that reasonably tend to inhibit employees from exercising their rights under the Act. We're going to talk more about this in a couple of specific areas here in a moment, because there are some work rules that you may not realize the NLRB considers to be violations. We can't deny off-duty employees access to outside non-working areas of your property unless business reasons justify it. So if you said, oh, nobody can ever stand around once you're off the clock because you're concerned that they're going to talk about unionization, unless you had some legit reason for preventing that, you can't do it. We can't prohibit employees from wearing union buttons, T-shirts, and other union insignia unless special circumstances warrant. A couple of years ago, while there was a big union fight with Delta Airlines, I observed, because I fly with them a lot, I observed employees wearing buttons about unionization, and you know, nothing the airline can do about it. They have the right to do that. We can't convey the message that selecting a union would be futile. A lot of companies try and do that. A lot of companies are like, hey, you know, you can unionize, but wait and see what happens next. You know, I mean, and some really large companies have implied that if their workforce in an area were to unionize, they would just completely shut down an operation or close a store or whatever the case might be. And that's definitely a very risky thing to do. And some of those companies that do that are really large, and they're taking a calculated risk, and they've got the money to defend themselves, but definitely something that's very risky. We can't discipline or discharge a union represented employee for refusing to submit without a representative to investigatory interview. These are called Weingarten rights. So anytime an employee is represented by a union, they have the right to have a union representative with them anytime they reasonably believe that they're being interviewed and it may result in discipline. Now, there's been some debate over the years as to what the extent is that Weingarten rights apply to non-union employees, and it's kind of been a back-and-forth thing. At one point several years ago, it appeared that Weingarten rights did apply to non-union employees. So, for example, even if you were an at-will employer, an employee could say, hey, I want another employee with me present when I'm being, you know, interviewed. That appears not to be the case based upon subsequent decisions, although who knows, that could become the case again. We can't interview employees to prepare a defense in an unfair labor case unless you provide certain assurances. So, and this just talks about that. So if we're being sued for an unfair labor practice, the ability to interview employees to prepare a defense is limited. We can't initiate, solicit employees to sign or lend more than minimal support to or approval of a decertification or union disaffection petition. So unions can be decertified, and this does happen from time to time where employees just feel that the union is not representing their interests. They can decertify the union. And while the employer may think that's the greatest thing ever because they're tired of dealing with the union, once again, they can only provide minimal support to that effort. So be really careful. We can't discharge, constructively discharge, suspend layoff, fail to recall from layoff, etc., or take any adverse action against an employee because of their protected concerted activities. So that's why those employers we talked about earlier got hit with those large penalties, because of the fact that they had discharged employees who were involved in protected activities. So let's talk about some things that fall into this sphere that maybe you haven't thought about. And one of the big ones is social media policies. Which, gosh, you know, who saw this coming, that the National Labor Relations Board would become the main federal agency getting hung up on social media. So in 2012, the NLRB began scrutinizing social media policies. Actually, it's probably started a little before that. The kinds of policies they found issue with are really very common. So if you look at some of the things that they found an issue with, you'll say, wow, that makes sense. I can see why an employer would want that. Well, the NLRB disagrees. They call these overly broad policies, and you'll see what we mean by overly broad. So here's an example from the NLRB. This comes from an employer. These were mostly large employers, and the employer policy said if you enjoy blogging and using online social networking sites such as Facebook and YouTube, otherwise known as consumer-generated media. I don't know who uses that term. Please note that there are guidelines to follow if you plan to mention our company or your employment with our company in these online vehicles. Don't release confidential guest, team member, or company information. This, on its face, seems reasonable. You don't want your employees releasing confidential information, right? Well, according to the NLRB, this could prevent employees from releasing information about the company, its financial performance, wages, working conditions, etc., because an employer could consider all of that to be confidential. And because of that, this is a Section 7 violation. So we learned two things from this. One, don't do this in your social media policy. Two, be really careful about overly broad confidentiality policies. I see a lot of employers that have these really broad confidentiality policies in their handbook that would not withstand scrutiny from the NLRB. I'm 99% sure of it, because they're so broad that it would be very easy for an employee or supervisor to interpret that that would prohibit discussions of wages or working conditions. Here's another example. Think carefully about friending coworkers. What's the employer concerned about? The employer is probably concerned about hostile work environment claims, sexual harassment claims, bullying, all that stuff that an employer has to worry about. They're like, oh my gosh, it's hard enough to control this in the workplace. I don't really want my employees harassing each other on Facebook because I'm going to get drawn into it. Sorry, life's rough. Discouraging your employees from communicating with each other outside of work is a Section 7 violation. Here's another one. You can see respect privacy. If we become aware of personal information about other employees, contingent workers, customers, patients, providers, etc., don't disclose that information on social media. Once again, that seems reasonable. We don't want you blasting stuff about our company out on social media or other employees. This is overly broad. It could prevent employees from discussing their wages or working conditions. Respect all copyrights, including our own copyrights, trademarks, and brands. So this employer doesn't want its employees festooning their MySpace page, or I guess nobody uses MySpace anymore, but Facebook page with their logos or artwork or anything like that. Well, that's a prohibition. That's not a prohibition. It's a violation under the NLRA, and the reason it's considered that by the NLRB is because employees may need to use your brand name, your logo, etc., to make posters and signs saying how awful you are if they want to picket you. So they have that right. Now, we can prohibit them from commercial use of our copyrights, trademarks, and brands, but we can prohibit them from non-commercial use. This is about an open door policy. This isn't really social media, but this is about an open door policy. This employer didn't want employees to use social media or other online forums to resolve problems. We want you to do it by speaking directly with coworkers, supervisor, or other management level personnel instead of complaining online. They have a right to complain online. The NLRB considered this policy to be overly broad and a Section 7 violation. So here's a story about a company, Valero Services, and it's a decent-sized company. They operate refineries all throughout the United States, so big company. They had a social media policy. They were forced to rescind their nationwide social media policy and to post and mail an NLRB remedial notice to its employees throughout the country in response to a complaint filed by the National Labor Relations Board. And the reason was the United Steelworkers of America filed an unfair labor practice charge with the NLRB, alleging that their social media policy interfered with employees' rights to discuss their terms and conditions of employment on social media. NLRB liked it, and so they had to go and post notices in their 52 facilities, mail notices, all this stuff because their social media policy was overly broad and restrictive. And so, you know, they didn't get hit with big fines and penalties, but they did have to go through a lot of work and eliminate a policy that may have had some good pieces to it. Another area where the NLRB finds an issue with a lot of employee handbooks are at-will policies. They're concerned about any kind of overly broad statements regarding at-will status. They're especially concerned about acknowledgement forms. Some employers have employees sign like handbook acknowledgement forms that effectively say, I'm going to be an at-will employee forever, okay? And that's never, ever going to change. And so if we have a handbook that says that our at-will status can't be changed or implies that at-will status can't be changed, and particularly if we make the employee sign any kind of acknowledgement form that is tied in with that, NLRB has a big problem with it. And many employers have policies that are like this that can be problematic. Now, the only way we can know is to look at your handbook, because sometimes you just don't realize that this stuff is buried in there. But a lot of acknowledgement forms need to be seriously amended because of this scrutiny. And my new acknowledgement forms effectively just say, hey, I acknowledge I got the handbook. It's really all you need if you end up in court. All you really need if you end up in court is proof that you gave the employee the handbook. They don't have to agree to it. If they're an at-will employee, you're not seeking their agreement. In fact, seeking their agreement makes it sound more like they're a contractual employee, which is exactly what you don't want to have. So be really careful about those handbook acknowledgement forms. We're not asking them to agree with our policies. We're just asking them to acknowledge that we gave them the policies. They're an at-will employee. They have to follow the policies whether they like them or not. Open door policies. I mentioned this earlier, but many handbooks include open door problem resolution policies. Usually employers like this because they want to help resolve problems inside the company. It costs us a lot less money as an employer if we can resolve any workplace problems inside the company instead of having to deal with lawyers or government agencies or unions. So employers often have this kind of policy, and it's a good policy to have. Just got to be careful, because if it makes it sound like the employee can't seek outside assistance. So if, like that one policy we saw before that made it sound like, hey, you really need to talk to us if you have a problem. You don't need to be on social media. You don't need to be talking to anyone else. Then that could be a Section 7 violation, according to the NLRB. The latest foray, and this is very recent, we just did a blog post about this recently, it regards email use. So the NLRB has now decided that employees are protected when they use an employer's email system for communications protected by the Act. So if I send an email to another employee saying, hey, it really stinks that our benefits keep getting cut at this company, we should do something about it, and the employer looks at that and decides that they want to discipline me, they have a potential problem. So employees, just as they can't be disciplined for discussing their wages in person with another employee or third party, this new ruling provides similar protection if they use the company-provided email. You just need to assume that any communication between employees about their wages or working conditions is going to be protected. Now, the decision doesn't require us to give email access to employees so they can complain about us. We don't have to do that. But if we already give them email access, and we let them use their email on non-working time, then we probably have to let them use it to complain about us as well. And, these are the kind of things that a lot of employers, they might say, hey, you can't use our company email system to send out an email to all the other employees trying to form a union. Yeah, but if you let them send out other non-work related emails, which lots of companies do, you probably have to let them do that. All right, so we've gone our 50 minutes, which is what we schedule for these hour-long webinars. If there were any questions, hopefully you input them already. We've got quite a few people online, so I don't know if that means we're going to have a lot of questions or not. Complicated topic, but please plug those questions in, and I'll be happy to answer them as best I can. Just as an FYI, we are publishing a white paper in the next week or so on this topic where we'll get into a little more detail and include some sample policy language and things like that that will hopefully be helpful to you, just things that we couldn't cover in our 1-hour webinar. So let's open it up for questions.
All right, thanks a lot, Chris. We do have some questions. So just before we get into them, as a reminder, if you do have any as we go along, just enter them into the questions dialog box, and we'll go through them in the order they came in. So the first question here, our employee manual makes no mention in informing employees they are not allowed to speak about wages. Can we restrict our employees from talking about other employees' wages? We state,
nope.
Okay. We state in our handbook that employees may not disclose other employees' personal information. We feel that includes their wages. Are we in violation?
Yeah, the NLRB has specifically addressed this on several occasions, and employees are allowed to talk about other employees' wages. So I, for example, could go to, so I could, if I knew the wages of, let's say, employee B, and I'm like, that's not right. They're getting paid more than me for doing the same job, and I'm unhappy about it. I can go to employee C and say, hey, did you know that employee B is getting paid more than us for doing the exact same job? And that is a protected activity under Section 7, and there's been numerous occasions where the NLRB has held that. And so now we can generally prohibit managers who are aware of confidential information from disclosing it because the NLRA doesn't cover management. So for example, we could prohibit a payroll manager, if they really meet the requirements of the law, of being a manager from disclosing employee wages because they're considered a manager and they have access to confidential information. But if I, as just Joe Blow employee, find out that somebody's getting paid more or less or whatever and I want to talk about it, that is actually protected by the Act. So, common problem.
Okay. Next question. What is acceptable language for the typical non-solicitation policy in an employee handbook?
Well, I don't want to say what the typical language is. It really depends upon what the employer is trying to accomplish. For a lot of employers, solicitation isn't necessarily a huge concern. Employers can generally prohibit employees from soliciting for other commercial ventures. So, for example, you could prohibit your employees from engaging in any other kind of commerce while they're on the clock, so selling Avon or Tupperware, or I don't even know if anybody does that anymore, but whatever the latest thing is that people sell, recruiting people for, network marketing programs, etc. All of that, you'd be pretty safe grounds. You just have to be careful that you don't have such an overly broad non-solicitation policy that it implies that that they can't solicit for a union. And so sometimes what employers will do is they'll have, fairly restrictive non-solicitation policies, but then they'll include what's commonly referred to as a savings clause that says, well, this is what we're saying, okay, but we're not prohibiting you from talking about unions. And, the extent to which that works is going to depend a lot upon what the rest of the policy says.
All right. Can you go over the point of where employers cannot keep employees from discussing pay?
It's relatively simple. You cannot prevent employees from discussing pay. I mean, I don't want to be flippant about it, but you just can't. There isn't like a line of, oh, we can discourage you, or you just can't. The ability to discuss their compensation is a central protection under the Act, because there's no way that employees could collectively organize if they're not able to discuss their wages and working conditions. And so, in effect, I can't imagine any kind of a policy that discouraged employees from discussing their wages that the NLRB wouldn't find a problem with. Maybe such a policy exists, but in general. Now, you don't have to put in your handbook, hey, we encourage you to talk to each other about your wages. You've just got to make sure that you don't have policies that imply or prohibit that they can't talk about wages, and you've got to make sure that your supervisors know that, because sometimes the problem isn't the handbook. Sometimes the problem is the supervisor who disciplines employees because they think that that's something that they're allowed to do. That, oh, we've got a prohibition against discussing wages, and they don't even realize that that's a protected activity. And like I said earlier, it's not just that individual employee's wages. They could be talking about somebody else's wages, and that's protected too. Or they could be talking about benefits. Or they could be talking about, hey, I just heard that we lost the, whatchamacallit project. I bet that's going to lead to layoffs. That's protected as well. So even non-wage information that maybe the employer considers confidential, like the fact that they just lost a bid on a big job or that their financial performance is suffering, anything that could be relevant for employees who are attempting to figure out if they want to work together to improve their wages or working conditions is going to presumptively be protected under the Act.
Okay. Is there a recommendation for employers who want an open door policy? Obviously, there's a person who would be responsible for taking complaints, grievances, etc. Do you recommend employers not use them or add language that covers the NLRB concerns?
Sorry.
No, just one more sentence. If the language is to be added, do you have a sample information?
So what we typically do is we have an open door grievance policy. I don't know if ours is called grievance. In our latest sample handbook, I can't remember if we call it grievance or open door, but whatever it is, it's the same basic idea that says, hey, if you have a problem, we want you to come to us. If you're not comfortable going to your direct supervisor, here's how you can go up the chain of command to try and find a resolution to your problem. We're going to work with you, etc. And then we've got a nice savings clause in there that says, hey, if you don't, nothing in this policy prohibits you from going and talking to somebody outside, even though we believe that, it's best if we work together or something like that. I don't remember the exact language, but the gist of it is that we're encouraging the employee to talk to us while not prohibiting them from talking to someone else. And that's the balancing act that you've got there. I'm just going to pull up a copy of look at our policy here real quick. Complaints and grievances is what we're calling it this day. We don't even call it an open door policy anymore. Handbooks are something that you're always modifying. So here we encourage first the employee to work with the other individual in an open, respectful manner to find a resolution. If you can't do that, then we want you to go to your manager. If that doesn't happen, you can go up the chain of command without fear of reprisal or retaliation. The Director of Human Resources may advocate on your behalf to help you achieve a satisfactory resolution. Talk about the fact that some problems are very difficult to resolve. That's just sort of common sense, but we want to always make sure employees realize that particularly interpersonal problems, just where they don't like another employee, sometimes there isn't a good resolution. And then we say that while the company encourages direct and open communication with management, this policy is not intended nor should it be construed to interfere with employees' rights under Section 7 of the National Labor Relations Act to seek outside assistance or work with other employees for mutual aid and protection. So that's sort of a generic savings clause that we include. Even though we don't believe our policy is necessarily a problem to begin with, we go ahead and throw in that little savings clause at the end to make it clear that we are not prohibiting them from going outside of the company for help. And that's always a good backup with your policies. But once again, it depends on what your policy says. If the first paragraph of your policy says, hey, we're going to fire you if you talk to anybody outside of the company, and then you throw in a savings clause, that's not really going to do you any good. So the policy has to be good, and you have to have the savings clause if you feel that you want to add that extra layer of protection.
All right. Regarding the discussion of handbook acknowledgement forms and problematic employee policies, these are risky only if the NLRB has occasion to review your handbook and policies. Is this correct?
Yeah, it only matters if they look at it. It's just like any other employment law. I mean, you could have anything you want there in it, and if nobody ever looks at it, then it's not going to be a problem. What I would say, though, is that we certainly see the NLRB looking at a lot more handbooks than they used to. And so as employees become aware of the fact that the NLRB has taken this much more activist role particularly in regards to handbooks, your handbook may come under scrutiny even if you aren't involved in any sort of labor dispute. A lot of times employers assume that this stuff only happens when there's some kind of major labor dispute, and that's just not true. You could just have one disgruntled employee who's ticked off about something and decides that they want to make a complaint to the NLRB and provide a copy of your handbook, and then all of your handbook could come under scrutiny. So no, it's not as if you have to send your handbooks into the NLRB for review. They couldn't handle it. They don't have the bandwidth to deal with, millions of handbooks or however many handbooks they would receive. But if you've got a ticked off employee or something like that, then it's definitely easy to imagine a situation where that would occur. And that's why I used some examples from smaller employers earlier. Remember we had the Dental Association, small employer. Then we had the doctor's office, small employer. It's not just huge employers who are getting complaints registered against them. A lot of times it's small employers as well.
Chris, does the NLRA prohibit HR staff members from disclosing wages?
So, it does give you greater discretion with people who have more access to confidential information. So, for example, you probably, and you'd want to work with your attorneys to have a confidentiality agreement drawn up for those employees who have access to particularly sensitive information, like so your payroll person who runs all your payroll knows everybody's wages. You've probably got a chance that you could have a pretty strong confidentiality policy with them, not policy but agreement with them that would provide greater protection than just your rank and file employee might have. But once again, you're going to have a confidentiality agreement drawn up by an attorney who's familiar with the laws in your state that attempts to find that balance between what you can prohibit and violating either state or local law and or the National Labor Relations Act. So it's not impossible, and you certainly have a stronger case where you have an employee who has access to particularly sensitive information. That said, if the payroll person was complaining about their own wages, or they were complaining that another payroll person was getting paid more than them, you'd have a pretty hard time hiding behind that confidentiality agreement. Where you would probably have some protection is if they just were ticked off and publicized everybody's wages on the internet or something like that, just out of malice. That's where you would probably be able to go back and perhaps enforce that confidentiality agreement.
All right, I think this other question might be something you just addressed, but what if the employee uses wage information for a gain? For example, employee A used employee B wage to try and get a raise. Employee B did not disclose this information to employee A.
Yeah, doesn't matter. It really doesn't matter how employee A finds out that employee B is getting paid more. And it doesn't matter if they use it to try and get a raise. That's what the NLRA is there to protect, the right of employees to try and earn more money, whether it's by forming a union or by just, any kind of concerted activity or individual activity to better their working conditions. And so the fact that they disclosed another employee's wages, now if they're blackmailing the company, that's a different situation. So if I come in and say, hey, I'm doing the same job as employee B is getting paid, twice as much as me for doing the same job, I think that's a problem. That's not really blackmail. That's just, hey, there's a problem here that needs to be corrected. Now, if I go to the company and say, hey, I know that you're paying all of your employees different wages, and unless you give me a raise, I'm going to put that on the internet. Now that's a different situation. Now an employee has engaged in blackmail, which is a criminal issue. That's not working together for mutual aid and protection. That's engaging in a criminal activity. So I guess it just depends on the circumstances, and that's where you would need to engage, local legal counsel who knows the laws in your area and can figure out, to what extent that activity is protected and to what extent it might be a violation of some other law.
Okay, this is a follow-up to the non-solicitation policy question from earlier. The person says they specifically meant the piece of it that relates to handing out leaflets or literature in the workplace.
So you can if you want to prohibit handing out all leaflets and literature in the workplace, you can probably do that if it's a prohibition that covers you can't hand out literature for anything in the workplace, period, nothing. That kind of policy is usually okay so long as you never waive it and, let somebody hand out a Boy Scout flyer or whatever the case might be. You couldn't prohibit them from doing it in the parking lot or outside of your gate or whatever the case might be. So if you have a total ban on any kind of solicitation in the workplace and you don't let them solicit anything, by passing out leaflets or whatever, that's probably going to be okay. I say probably because you never know. But then all they have to do is stand outside the gate as employees are going out, and they can hand out the leaflets there, and there's nothing you can do about it. The answer is sort of yes and no. There's an easy workaround, which is they just do it outside the gate, and then they're still getting their literature out, and there's nothing you can do.
How does the discussion of compensation apply to managers? I was under the impression a manager could be prohibited from discussing compensation.
Right, because management, by definition, is not covered by the NLRA. So if we go back, let me just pull up my slides here. Hold on. If we go back to one of these earlier slides, play from current slide. So let's see. We actually had it on one of these slides. Anyway, managers aren't covered by the National Labor Relations Act. So in that respect, I don't know what slide it was. In that respect, you can have prohibitions against management that are different from your prohibitions against, quote-unquote employees. So in that respect, I had it in here somewhere, but now I don't know where it's at. But yeah, so you can hold managers to a different standard than you can employees because managers aren't covered by the National Labor Relations Act. Of course, you're going to get in trouble if you go and try and misclassify, improperly classify all of your employees as managers as an attempt to get around the law. Those employees have to legitimately be managers in order to be outside of the coverage of the law. But yes, managers are not covered by the National Labor Relations Act so long as they meet the applicable definition. And that's the key, is just make sure that you're not, I don't know where it went, to make sure that you aren't, broadly classifying people as managers in an attempt to take away their rights under the Act.
Thanks, Chris. Just a few more here. There are requirements set by the SEC that we require in our social media policies, some of which may go against what is required or prohibited by the NLRB. Would have to check on specifics, but what happens when two sets of regulations clash?
Well, sometimes it's just a lose-lose for the employer, honestly, and we see this in a lot of areas. So what you would have to do is you would have to try and look very specifically at what the FTC or I don't remember whichever agency it was, the SEC, I guess, was who you're talking about,
Yep.
what the SEC prohibits. So the SEC is going to probably be concerned about the disclosure of any inside information, anything like that that could potentially be a problem. We actually kind of address that in our social media policy, believe it or not. At least I think we do. I know we have a version of a social media policy that does address that. I don't know if it's in this handbook or if it's an optional policy, but we do have, that's one of the issues that we've dealt with before, where we do prohibit, for example, the disclosure of any information that would be, I don't think I have it in this version. I think that's an optional policy. But we do have a policy like that deals with, that kind of protected information that could be used, for example, for insider trades or anything like that, where there's going to be those kinds of prohibitions. So it's not necessarily impossible, but it's also not that unusual that you have seemingly contradictory laws. And so sometimes complying with one set of federal rules might put you in a pinch in regard to another one. another set of rules, and that's not altogether unusual, unfortunately. The agencies aren't required to talk to each other to make sure that their rules are all consistent, particularly when you're talking about something very narrow like the SEC versus something very broad like the NLRB. You know, you've got an agency with a very narrow mandate on the one hand in regards to who's covered by it, and a very large mandate on the other. And so it's not that unusual that you'll see those kinds of contradictions.
Can an employer threaten to terminate an employee for posting their resume to a job site?
I don't think that would be covered by the NLRA. You're kind of asking for legal advice there. You know, sounds like a specific circumstance. I don't see how that would be covered by the National Labor Relations Act. I still would tend to think it's a bad idea because it may violate some other law, or there could be some other circumstance that we're unaware of that could be problematic. But from the standpoint of the NLRA, which was our focus of our discussion today, the NLRA doesn't really protect the rights of employees to look for other jobs. It protects the rights of employees in the job that they currently have. So I don't see that that would be directly addressed by the NLRA, or that the NLRB would even get involved. But there's certainly plenty of other opportunities for an employer to get in trouble if they have that kind of, take that kind of stance.
Okay. In regards to the termination question, what policy protects employees in this situation?
Termination question. Which question was that? Can you
backtrack for me? I'm trying to think of it as well. So if that person could just provide a little more light. I don't have the previous questions available, but we'll go on for now.
Okay.
The next question: do you mean managers cannot discuss a subordinate's pay?
Well, yeah, you could prohibit managers from discussing anyone's pay because managers aren't covered by the Act. So you could have a policy that says managers and supervisors aren't allowed to ever talk about anyone's pay, and in theory, as long as they really qualified as managers and supervisors under the Act, they would have no recourse under the National Labor Relations Act because managers and supervisors aren't covered by the Act.
Okay, and the next one, if a manager is discussing his own pay with another manager, is he then covered as an employee?
The general answer is if they're a manager or a supervisor, they're not covered by the Act. So does that mean that a manager or supervisor could never seek protection? I don't know. That's a hypothetical that I wouldn't want to get into because they could always argue that they didn't really meet the definition of manager or supervisor under the Act. But once again, I'll just go back to the general response, which is managers and supervisors aren't covered by the Act, so the things that we've been talking about in general will not apply to them.
Okay. If an employee who works for an at-will employer requests a witness or their attorney to be present in the disciplinary meeting or investigation, does an employer have to allow this?
Right. So here we're talking about the Weingarten rights, and Weingarten rights unambiguously apply to union employers, but there's been a lot of back and forth on to the extent to which non-union employers have to deal with Weingarten rights. And so just for the heck of it, while that question was coming in, I just went and looked. I just did a Google search. And here's a publication talking about the fact that courts have flip-flopped on Weingarten rights for non-union employers. And so we've seen contradictory rulings on the extent that Weingarten rights apply to non-union employers. So if it were me, just to be safe, if someone was really insisting that they have a representative present when they're subject to disciplinary investigation, what does it hurt? Okay? I mean, what does it hurt? I don't see how it's a big negative for the employer to allow that other person to be present. Sure, you could refuse it, and you could fight in court about it, and maybe you would win, maybe you would lose. The courts have flip-flopped on whether or not that right exists for non-union employees. But if it were me, I would just let them do it. I mean, what's the big risk to the employer? I think that the risk to the employer is minimal compared to the risk that they end up in some big fight with the NLRB and or they end up in court because they didn't allow a representative to be present. So because it's gone back and forth over the years, and there isn't in my mind an absolutely clear rule on that.
All right. Well, that appears to be our last question for the day. So everyone, I appreciate your time today. Chris, I appreciate the presentation and the questions. So we hope you can join us again for our future webinars, and we look forward to seeing you again soon. Have a great day.